Good morning, everyone, or I should say good afternoon or good evening, depending on when you're watching this webinar. I'm Linda McAlary-Smith, the Victorian Small Business Commissioner. Thank you so much for joining our webinar today on all things retail leasing relating to retail leases in Victoria. We have a number of people who are joining us online today, and we will also be making this webinar available online for viewing at a later time. So whether you're joining me right now or you're watching this later, thank you very much for participating with us today. I would like to start by acknowledging the traditional custodians of the lands on which we're meeting, the Wurundjeri people of the Kulin Nation, and pay my own respect to elders past, present and emerging. Thank you again for your time dialing into this webinar about retail leasing in Victoria. We've got 30 minutes today to cover a number of key issues in the retail leasing space. So I will have a slide deck, which I will share in a moment, and that will also be made available after the webinar as well. And I really do encourage you, if you have specific technical things that you'd like further information on, please don't hesitate to jump onto our website at www.vsbc.vic.gov.au, because there's a wealth of information there for you about all things retail leasing and indeed more broadly about the Small Business Commission as well. So without further ado, I will jump into our webinar today about retail leasing. I do, for those of you who I know are dialing in from interstate, please be aware that this relates to the Retail Leases Act within Victoria. There are similarities and similar jurisdictions across the country with different pieces of legislation, but if you are interstate, please just keep in mind that there may be some variances. So what we'll cover today will be, I'll provide a quick overview of the Retail Leases Act, which from here on in, I'll hopefully try to remember to call RLA in terms of speeding up the process of getting you this content. I'll be covering the common disputes that we see at the Small Business Commission here and how to avoid them. I'll also be talking through how to apply for assistance from the Small Business Commission. The Victorian Small Business Commission has been in place for over 21 years, and we're an independent government-funded agency who is set up specifically to help small businesses navigate a whole range of business-related disputes and also to provide support in specialist areas, including retail leasing. So without further ado, we'll dive into the Retail Leases Act 2003. The Retail Leases Act, or RLA, was established back in the day to effectively address an inequity in bargaining power between landlords and tenants, and particularly from a small business perspective, recognising that when dealing with a landlord, when you've got a bricks and mortar premises for your business, that often there'll be an imbalance in power from the small business perspective to the landlord. Not all of our retail landlords are, big landlords, if I can put it that way. In Victoria, we do have a large number of retail landlords who are in fact what might be called a one property investor, for example, or family investors, right through to the super large shopping centres who have thousands of businesses on their books. So the Retail Leases Act started because the situation was arising, or it was recognised at the time, that small businesses needed some additional protection in relation to retail leasing, and that there were issues in relation sometimes with what small businesses would encounter with their landlords, and small businesses didn't necessarily have anywhere to turn that was economical, so not super expensive like marching off to court, and also to get advice and assistance. So under the Small Business Commission jurisdiction, at the Victorian Small Business Commission, we provide this dispute resolution service for retail landlords and tenants. So landlords, retail landlords are very welcome to come to us as well. We are independent and impartial when it comes to our dispute resolution work, which means we are not acting on behalf of the tenant, even if they're a small business, and we're not acting on behalf of the landlord. We are an independent, circuit breaker in the middle, that our job is to create a safe space to provide affected parties with a dispute with high levels of expert dispute resolution skills and services in order to hopefully resolve that dispute. So what I'll be sharing with you today is, because we work in dispute space, we get to see a lot of things where things have gone wrong. So whether either mistakes have been made or parties perhaps haven't necessarily been as clear as they could have been with each other, or everything's clear but one party's done the wrong thing. So I'll be talking through some of the things to watch out for if you are in the retail leasing space, or if you're aspiring to move into a premises to start to grow your business, if you've been operating from home, or you're looking at moving around, or you're already in the market as it is at the moment. So retail leasing disputes, by and large, have to come to the Victorian Small Business Commission before they can actually go on to the tribunal if there's an issue that needs a determination. There are some exceptions to that. Effectively, if a lease, though that provision that I've referred to in large applies to situations where the combined rent and outgoings does not exceed $1 million for the year as well too. Noting that some of the additional protections under the Retail Leases Act were specifically designed for smaller businesses. So in terms of some of the disputes that we see, I thought it would be really useful to give you a bit of a peek under the hood of what we see. We deal with thousands of small business disputes. We've seen every kind of situation imaginable. We played a key role in supporting small businesses and commercial landlords through COVID with the Commercial Tenancy Relief Scheme. So this gives us a bird's eye view as to where things go wrong. I should say we are also, and this is the point of why I'm talking to you today, we're also here to help make better decisions, to help get things right in the first place, to help be fully informed about what your rights and obligations are. So I'll have some contact details at the end of the webinar of how you can get in touch with us, either on our website or also just pick up the phone and have a chat to us as well too. Ideally, we would like to be able to give you that advice and information before you weigh into a retail leasing situation, or if you do come across any problems or challenges, you know that we're here to help you. So the kinds of things that we see, so at the moment, the predominant issue that we would be dealing with in the retail leasing space for disputes is that there's arrears owed, so that there is money owed by the tenant to the landlord. I would say that I think this is a feature of both the current economic climate, but also the preceding years, particularly the impact of COVID in Victoria, is that when we're dealing with a dispute where the tenant is in arrears, usually the sum of money involved is quite significant. It's quite rare for us now to be dealing with a retail leasing dispute where money's owed that's not in the order of at least a couple of $100,000. It's really common for it to be over $500,000, and it's not uncommon for us to see arrears that are actually at seven figures, which can be really difficult from the tenant perspective, because if you're a small business and you're carrying that kind of debt, and usually if rent is owed, usually there's debt owed to others, be it to the Australian Tax Office, to the ATO, be it to other providers, or debt on credit cards or finance as well. It's not often we would see a situation where there's a significant amount of rental debt and it's the only debt that the business is carrying. So that is a huge challenge for our businesses at the moment when you are carrying a high level of debt and working in an environment where there's input pressures, there's cost pressures from your customers in terms of ability to increase prices as well. So one reflection I would have is that if you are in that situation, or you're advising others who are in that situation, it's really important to reach out for help as early as possible when you've got the maximum amount of options and pathways available to you. So that could be to your landlord, that could be to the bank, that could be to the ATO. Please reach out as quickly as you can, because when you are accruing arrears, it just keeps getting worse and worse if it's not addressed. And the sooner that you can actually have a conversation, hopefully a constructive conversation with the entity that you owe money to, the sooner that you can actually look at the full suite of options that are available to you, rather than the ATO makes the decision for you, for example. So there's really limited circumstances, I would say too, where tenants can withhold rent. We do see this from time to time, where there is a dispute often about repairs and maintenance, or a dispute about an issue that the tenant has had with the landlord, and they feel that that's a tactical advantage to actually hold on to the rent, because they feel that that's forcing the landlord's hand to actually engage with them to try and resolve whatever the issue is. Under the Retail Leases Act, there's very limited circumstances circumstances in which a tenant can withhold rent. There are some, but it's really important that you appreciate what you're doing if that's a pathway you're going down. So I couldn't emphasize enough that if you are a tenant and you're thinking that the next step for you is to hold off paying rent or part of the rent to your landlord, that it is absolutely critical that you seek advice before doing that. Because if you end up doing that when you're not allowed to do that, or doing it in a way that's not the right way, you can end up in all sorts of trouble and drama, including getting evicted. So if that's something that you think is a legitimate option that's open to you, just make sure that you check that that's right and double check before you do that. The reality of retail leasing disputes, what we're dealing with at the moment, is all the disputes that we deal with that involve arrears involve other issues as well. There is for the technical people on the call, there is a carve out in the Retail Leases Act that says if your dispute is only about arrears, if you're a landlord, for example, you don't have to come to the Small Business Commission before going to VCAT. In our experience, most landlords do still come to us, because in 100% of the situations we deal with, even if the main course is really about rental arrears, a tenant will always have other issues to raise. And that could be about accuracy of disclosure statements, it could be about outgoings, it could be about historical repairs and maintenance. So what we are finding is that even if it's really mostly about arrears, that landlords are still choosing to come to the Commission to make sure that they cover off the process required under the Retail Leases Act. And for those who don't know, the reason behind that is if you march off to VCAT and you're meant to have come to the Small Business Commission first, VCAT won't accept your legal proceeding, or if it does manage to kind of sneak through the cracks there, they won't hear it and they'll send it back to us. So that's why we find that landlords, even if it is predominantly about arrears, will come to us anyway. So options in terms of when money is owed by the tenant, even if you think, look, it's unrecoverable, it's at a certain sum of money that you're just not going to be able to pay, we really do still encourage you to engage in our alternative dispute resolution process and service. There's a whole range of different options that can be available. It can include thinking about how you might exit a premises, discussing the timing, discussing making good and what you do with the fit out. There's a whole range of different things that you can work through. And there's payment plans are something that we see quite regularly as well, where tenants have been able to enter into an agreement with their landlord for a payment plan. Now, I would say to be mindful that post the COVID period and some special rules are in place then, you don't have an entitlement to a payment plan as a tenant, but it's always worth having the conversation with the landlord if you think you've got a viable plan to be able to trade out of the difficulty that you might be in at the moment. And as I said, there's other things that can be negotiated as part of that dispute resolution, including potentially surrendering a lease in the best way possible. Often there's really difficult decisions on the table and none of them are good, but it's about working through together to figure out, well, which is the least worst option for both the landlord and the tenant. And we do find that there can be an alignment of interests in that space. So if there's some information there in the slide too, I'll keep moving through because we've got quite a bit of technical content to get through. And as I said, there'll be the slides will be available afterwards as well for you to reference. So in terms of early termination of the lease, there are some circumstances where a tenant is able to terminate a lease where they have a right to do so. Otherwise, broadly, it's by negotiation. So if you've signed up to a lease and that things aren't panning out, it is really imperative that you be having a conversation with your landlord and ideally informed by advice and educated as to what your rights are, as well as the landlord's rights. A lot of what we do in the dispute resolution work when we're talking to parties in dispute is actually try to work through and have each party see the other person's perspective. You might not agree with it, but that's just that ability to actually stand in the shoes of the other person and ask those kinds of questions of why are they behaving like that? What outcome are they looking to get? What would be in their best interest? Or why might they be saying no to this? Or why might they be obstructing this? We find that when we can encourage the parties to both sides, sometimes there's multiple parties involved too, but to look at the other and kind of stand in their shoes and try and think, okay, what's driving their behaviour or their position or their outcomes they're looking for, that's a really powerful process to go through that can actually help you come to an agreed position where you can resolve the dispute. So in terms of, you can see in the slide there's some of the circumstances where there's an entitlement for early termination of lease, and that can relate to things related to inaccuracies in the disclosure statement. It can also be in terms of if the property is damaged and not fit for purpose and there's no reasonable time frame to bring that up to speed. One thing I would say is that with disclosure statements is to please be aware that disclosure statements need, in terms of estimates of outgoings and the like, need to be as accurate as they can be at the time that the disclosure statement and the estimates are made. One thing that we're seeing pretty regularly at the moment is sometimes a disconnect between, for example, if energy prices are included, that energy costs, the actual end cost being higher than what was estimated. And with the economic environment we're in, with costs going up, just because the costs are more expensive won't necessarily mean that there was anything wrong with your disclosure statement or the estimate you received at the time. It's that, was it accurate at the time as well too? So that's something to keep in mind as well too. So moving along in terms of the repairs and maintenance, going to that point about, okay, something's happened to the property that I'm leasing and it's impinging on my ability to run my business, or it's not in the same standard to which I actually leased it. So the landlords have a responsibility for maintaining the premises as it was when it entered into the lease. So that's a really important part. They don't have an obligation to make it better. If you are having conversations with a potential landlord or their property agent, and there's promises being made about, oh, you know, before you move in, we'll do X, Y, and Z, or once you're in, we'll make sure the painting gets done, or we'll do something to the kitchen or the bathroom. Always, always, always make sure you get that in writing. And if that intent is genuine, there shouldn't be any hesitation to be able to confirm that for you in writing, even just an email or something. We do unfortunately see situations where promises are made to a tenant verbally that are not reflected in the lease, and then when the tenant actually gets in, that's not followed through, and it's a really difficult thing for a tenant to be able to then say, well, actually, I'm entitled to what you promised. If there's A, no proof of it, or B, there's no confirmation that both parties agreed to what the whatever the issue was. So please do, and we do see, unfortunately, semi-regularly, where agents acting on behalf of landlords can sometimes represent, sometimes potentially willfully, other times just sloppily, might represent a particular or say something to a tenant in terms of encouraging them to get in. That might not exactly marry up exactly with what the landlord's expectations are or what the landlord's willing to do. So if you are getting in writing, it's really important, if you're getting it from an agent, to make sure that the agent's being really clear that they're acting on behalf of the landlord and they've got the correct instructions. The benefit of that is there just minimises any confusion. So if there is a bit of confusion, or you've heard something that you've heard it in a different way to the way the person intended to, sorting all this stuff out before you actually enter into the lease means there's no confusion. So if it's like, oh, I thought you meant that. Oh, well, no, I didn't actually mean that. In fact, what I meant was this. You work all that out beforehand, and then you know exactly what you're getting into. So landlords are responsible for maintaining the property in the condition in which you received it. So that goes to structures, fittings, plants and equipment that are there for your usage, goes to gas and electricity, drainage, fittings and fixtures, again, if they were in place for you at the time, and they all have to be maintained in a situation that's consistent. So if for example, I'll use an example of, say, like an older kitchen or something's already there, you don't have a right to have that improved, but you have a right to have it maintained in the standard to which it is. I really encourage you, if you are incurring issues with getting repairs and maintenance done, or if you're a landlord and you're not sure where the line is in terms of what you're obliged to do versus what you might choose to do as well, don't hesitate to give us a call or jump onto our website. We've got a heap of information that's available for you. And every time we have a massive downpour, we're used to getting lots of contacts from people, both from a landlord and tenant perspective, because leaks, and saying, okay, what are our next steps and what are our rights and obligations. I'll keep whizzing through because I know we've only got 10 minutes left to go. Making good at the end of the lease. This is really, really, really important to pay attention to before you enter into a lease. It's really exciting if you are actually signing up to a lease, because either you've got your first bricks and mortar for the first time, or you're moving into a new premises that you're excited about, or you're expanding. So it can feel like it's a bit off in the distance to be thinking about what happens at the end of the lease. And it's not to want to take the special magic and excitement that you have, that you're looking forward to going into that premises. But looking at the make good obligations before you go in is absolutely important, because usually the expectation that's set out in the lease will be that the tenant will remove all of their fit out, repair any damage above fair wear and tear, and basically give the premises back to the landlord in the same state with which you've received it. So if you're inheriting a vacant premises, or it's been used as an accountant and you want to turn it out into a cafe or a hairdresser, what have you, there's money involved in doing that fit out. And a really common dispute we come across here is where at the end of the lease, the tenant has invested lots of money in the fit out. They're handing the keys back, and the tenant is, well, you've got these great fittings and fixtures and stuff that I've installed in there, so I'm going to leave it, and I don't want to bear the cost of ripping it out. And the landlord is, no, I need it as an empty shell, because maybe I'm renting it not to a cafe anymore, back to an accountant. It needs to be in the same state for which I gave it to you. We have seen businesses who have invested several $100,000 in a fit out in the last couple of months of their lease with no right of renewal. And then when it comes to the end of the lease, the landlord, as they're entitled to do, that's it, and they may lease it to somebody else. So the tenant not only has spent all that money investing in that fit out, but they also have to incur the cost of ripping it all out again. So that is a really common dispute that we deal with. And the tenants will usually feel that they've enriched the landlord's premises, so they feel that they shouldn't have to incur the cost of ripping it out, or the perceived waste of stuff getting chucked into landfill or what have you. And landlords will invariably feel that they need to be free, as they're entitled to lease it to whoever they want, and they don't want to incur the cost of having to rip it out to make it a more suitable premises for whoever they're leasing it to. So please, 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 there's one thing you pay attention to out of this webinar. Make sure you're across your make good at the end of the lease, and you plan for that and you factor that in from a cost perspective. And also, you don't leave it to the last minute on agreeing what needs to be done to hand the premises back. So making sure that repairing damage above fair wear and tear, don't leave that to the last minute. You need to have those conversations earlier, towards the end of the period, so that you can all ideally agree as to exactly what needs to happen, and then you can make sure that what work you do, if you're a tenant, or work you have done, that's signed and ticked off. You don't want to be in a situation where there's a new tenant in the premises and your landlord's trying to hold you to account for things that you didn't do that they've had to bring up to speed. It just gets incredibly messy and complicated. So lease options and end of renewals. So the Retail Leases Act prescribes a whole process, which I won't go into a heap of detail with today, but you can check out on the slides and also on our website as well at vsbc.vic.gov.au. There's a heap of information on there around what happens at if you've got an option and you've got a right of renewal, and also around how rent can be calculated as well too, and what to do if you can't actually agree on what the new rent should actually be. One function that we have is appointing specialist retail valuers. We do deal with a number of businesses, with the retail tenants and the landlords, where they are in such dispute they can't agree on who to appoint to do the valuation. So we actually have a role under the legislation to be able to actually appoint a specialist retail valuer, so that then the valuer can go and make their decision about what they think would be effectively a fair market, a market rent for the lease moving forward as well too. There are obligations on a landlord to let a tenant know that certain timeframes are coming up. So if you're a landlord, I really encourage you to make sure that you're staying on top of those dates and obligations as well. Make sure you're diarising them. Make sure your agent, if you're using an agent, is across them, but also don't just assume that your agent necessarily is doing that. People make mistakes, things fall through the cracks. So I just really encourage all parties who have some rights and obligations in this space to make sure you're on top of certain deadlines. And if you're the tenant, don't be relying on the landlord to follow through with that. There's a much better position to be in if everybody is taking their own responsibility for staying up to speed on certain dates and timeframes as well too. And again, put everything in writing in terms of agreement about renewals, be it terms, the term of the period, what the amount would be, any changes to your leasing terms. Make sure you get that in writing. Now, how to seek assistance. So, as I said, the Small Business Commission has been going for more than 2 decades, and we are really here to help you for our dispute resolution service. If it doesn't go through a formal mediation, there's no direct cost to you. That's fully subsidised by the Victorian taxpayer. If you do have to go on to have a mediation with us in a more formal way, we do all of those online, and the cost to the parties is $300 per party for one of our mediations. But 35% of the disputes that we get, we resolve with our internal dispute resolution staff. So there's no need to actually go ahead and have a formal mediation. Of those that do go on to have mediation, we resolve over around about 70% of those. So part of my message to you today would be it from a landlord perspective, a tenant perspective, or their advisors, is that if you have a dispute in retail leasing space and you come to us, the odds are really good that you walk away with the dispute resolved. So you can see the information there on the I've caught that on the slide as well in terms of the costs. In terms of the $600 for a full day, that is by exception. We generally only do half-day mediations because we find that that's usually the right balance in terms of the time, and also we have a huge demand for our service as well too. So we're managing our ability to serve as many small business tenants and as many landlords in the retail leasing space as we possibly can. So you've got the contact details there. So that's the website, as I've mentioned a couple of times, vsbc.vic.gov.au. You're welcome to send through an inquiry to our email box. 1800 878 964 is our 1800 number that's free to call. I would say in terms of the inquiries and the phone calls, the wait time at the moment to access our dispute resolution service, because there's a really high demand for our service, it's around 15 to 16 weeks for us to actually be able to action your dispute. In other words, for someone to get in contact and say, hello, thank you, we've received it. So you'll absolutely receive a confirmation if you jump on our web portal, which is on our website, to lodge a dispute. You'll absolutely get confirmation that it's all gone through. Please rest assured that it is with us and we will get to it as quickly as we can. And I would please implore you that if you do have a matter which is in our dispute queue, unless it is something urgent, such as you've been issued with a breach notice, and unfortunately that standard of urgent has to be objectively incredibly high, which effectively is getting towards injunctive kind of space, and an actual breach notice having been issued, we are getting to those as quickly as we can. So I would just implore you, please, if you are in the queue and you don't have a breach notice that's been served on you, to please not call us and ask us where it's up to, or not send us an email and ask us where it's up to, just because that takes us away from getting to being able to service your dispute as quickly as we can.